In the series of lectures on duties and liabilities of the trustees, we have seen in the last lectures the standard of care required under trust ordinance. In terms of section 15, a trustee is bound to deal with the trust property as carefully as a man of ordinary prudence would deal with such property if it were his own. Then from this section, in all the duties, not only in section 15, in all the duties, there's a standard of care required from trustee. Now, even though we have seen section 19 in the last lectures, today we will see once again for important matters, and we will, when we continue these lectures, you can understand the importance of section 19. A trustee is bound to keep clear and accurate accounts of the trust property at all the reasonable times at the request of the beneficiary to furnish him with full and accurate information as to the amount and state of the trust property. In the section 19, when you see that trustee is entitled, there is an entitlement to get clear and accurate accounts and information in relation to the trust property or the trust. On the other hand, a duty imposed on the trustee to permit such inspection of document. If the beneficiary wants a copy of the documents or the accounts, it shall be the duty of the trustee to give a copy of the accounts. If the beneficiary intends to have a copy of the accounts, he is liable to pay such amount of money for the purpose of obtaining such copy. Further, we can say beneficiary is entitled to file a suit for rendition of accounts against trustee. And even if the trustee dies during the proceedings, the suit can be proceeded with against his legal representative and heirs. A trustee is also equally entitled to file a suit for rendition of accounts against his co-trustees. And when a suit for rendition of accounts has been filed, the burden of proof is always on the trustees whether he is a plaintiff or defendant. The liability extends to the legal representatives. Now we will move to other section, section 19A. Section 19A inserted by an amendment to the Trust Ordinance in 2018. The Trust Amendment Act number 6 of 2018 inserted the section 19A into the principal enactment. When you see the section 19A, a trustee shall keep records of all such information as may be prescribed. As may be prescribed in the sense by way of regulation made by minister. That's why the same amendment 6 of 2018 inserted another section 115A by which the minister empowered to make regulations. Therefore, here the trustee shall keep the records, all information. Then what are the information that will be prescribed by regulation on the identity of following persons at the time of creation of an express trust? Trustee himself, co-trustees if any, author of the trust, beneficiaries. Sometimes it may be difficult to identify the beneficiaries, especially in the case of charitable trust. That's why here mentioned that beneficiary to the extent, greatest extent possible, and any other person engaged in the execution of trust in the capacity of an agent or legal representative or manager or an investment advisor or tax advisor or an accountant or otherwise, then whoever it is, if a person engages in the execution of trust, then there's a duty of the trustee to give. First of all, he must keep all the records regarding all information regarding all these people who are involving in the trust. As I told you, now under section 19A, all the records of all such information as may be prescribed. This is a regulation published by the minister. Trust information relating to express trusts regulations 2019, published in the Gazette number 2108/10, January 28, 2019. Now in this one we must study little bit deep, because you must know the provisions of this regulation. The trustee of any immovable property or movable property in respect of an express trust, not the constructive trust. This is only in relation to the express trust. The express trust may be for the purpose of charity or may be for the purpose of private trust. Whatever it is, the trustee of any immovable property or movable property in relation to the express trust shall, for the purpose of subsection 2 of section 6A, forward the information is specified in schedule 3. When you see the schedule 3 here in the regulation, it requires all the information relating to the persons. When you see this regulation, schedule 3, number of day book contains, this is a section schedule 2, schedule 3. That's a comprehensive details required. Name of the trust, the land registry, area applicable to the trust, address of the trust, purpose of the trust, information of the author of the trust, full name, valid document of identity or its number, address, permanent and residential address, and likewise information of trustees, information of co-trustees, information of beneficiaries, information of beneficial owners, and where the trustee has been created for the benefit of class of person, information of every person belonging to such class of persons. Again, full name, valid document of identity card or whatever then its number, address, permanent and residential, all required. And information of the instrument of trust, number and the date, and name of the notary public attesting the instrument of trust, the particulars of trust property, value of the trust property, and particulars relating to change, if any, of the trust. And these are the information required to be forwarded under Section 6A. And also, to whom we must send it? The trustee must send this information to the registrar of the lands of the area within which the trust property is situated. First, along with the original document of trust for registration. Then there is a basic duty of the trustee. First of all, immediately upon the creation of trust, the original copy of the instrument of trust, that's a trust deed, should be sent to the registrar of land for registration. And the Registrar-General, again, the Registrar-General send the documents to the Registrar-General of the copy of the instrument of trust. Then these are the all information, whatever information that I have discussed now, all these information, put it into the format as mentioned in the regulation, submitted to the Registrar of Land and Registrar-General of Lands. In addition to that, that's Regulation 4.2 is more important. The trustees of immovable property and movable property in respect of express trust that has been created prior to the date of coming to operation of these regulations shall comply with the provisions of Regulation 1 within 6 months from the date of commencing of these regulations. Now, there are trusts already created. In future, if the trust is created, then immediately the trustees must send this information to the Registrar-General as well as to the registrar of the place where the residual property is situated. If already, suppose nowadays, now if you see in Sri Lanka, there may be so many trusts created. Then all these trusts already created, the trustees under obligation, legal obligation, that's a legal duty imposed on the trustees, they must send this information to the registrar as well as Registrar-General for the purpose of registering those things. Then come to the 19B. A trustee or co-trustee, if any, of any express trust, once again express trust, shall provide to the relevant authority any information in the record maintained under Section 19A in respect of any person referred to in that section whenever such trustee is required to provide such information by such authority. Now, if there is a relevant authority, what is a relevant authority? It is defined in the Amendment Act. When you see the relevant authority here, defined under Section 19B, paragraph B, here only A appears, but B also there, better to see the Amendment Act here. For the purpose of paragraph A, relevant authority means any public authority assigned with the responsibility of preventing money laundering and suppression of terrorist financing. Any authority that performs the functions of investigating and prosecuting money laundering and terrorist financing associated offences and seizing or freezing and confiscating assets relating to such offences. Then generally speaking, it must be given to the public authority assigned the subject of prevention of money laundering and as well as suppression of terrorist financing. Then 19C. When you see section 19C here, a trustee who acts in contravention of the provisions of 6A. What is 6A? That we have seen now. 6A.1 is the Registrar-General shall prepare and maintain a register containing such information as may be prescribed, that already prescribed in the regulation. There are about 4 schedules. You can see that one. Then the registrar shall prepare and maintain a register containing such information as may be prescribed in respect of express trust created under in compliance of section 5. The first thing, a registrar shall prepare and maintain a register. Then subsection 2 imposes duty on trustee. The trustee of any immovable or movable property in respect of express trust shall forward to the Registrar-General for the purpose of subsection 1 all such information relating to trust as may be prescribed. That we have seen now. What are the informations that should be given to the Registrar-General? There are schedules, you can see that schedule. Now, then the 6A, first of 6A subsection 1, registrar shall prepare and maintain the register. But here section says a trustee who acts in contravention under 6A. 6A in the sense 6A2. 6A2 is trustee of the any immovable property or movable property in respect of an express trust shall forward to Registrar-General for the purpose of subsection 1. For the purpose of subsection 1 in the sense, registrar must prepare and maintain a register. For that purpose, shall forward the registrar for the purpose of subsection 1 all such information relating to trust as may be prescribed. Then here under section 6A, trustee shall forward to the Registrar-General all the information as may be prescribed. Then section 19, that's why I told you now, section 19 imposes another duty, the right and the duty. When you see that duty on the trustee, a trustee is bound to keep clear and accurate accounts of the trust property, and also if on the request made by beneficiary, he must give all the information, accurate information relating to amount and state of the trust property. So in section 19A we have seen, under 19A the details or the information relating to so many following persons: trustee, co-trustees, author of the trust, beneficiaries, and any other person, whoever engages in the execution of trust. All these information relating to all these people should be submitted. Then the section 19B, that's again we have said the trustee or the co-trustee, whoever it is, of the express trust shall provide all any information, whatever they have maintained under 19A, that's all the information relating to the persons must be given to, or shall provide, trustee shall provide all the information to the relevant authority. Who is the relevant authority? The public authority assigned with the responsibility of preventing money laundering and suppression of terrorist financing. If the trustee fails, commits an offense. If the trustee fails to do those things, then he commits an offense, punishable by fine not exceeding 200,000 rupees or imprisonment not for a term not exceeding 2 years, or both such fine and imprisonment. This is a very strict provision. In other cases, if there are so many duties that we have seen up to now, there are some more duties that we are going to see that. If the trustee fails to comply with the duties or fail to comply with the requirements or fail to do some duties, then there is a breach of trust. But here, whatever duties specified under 6A, 19, 19A, 19B, not only the breach of trust, but also trustee commits an offense. Then what is 6A that we have seen? Registrar-General shall prepare and maintain register containing such information as may be prescribed. The trustee of all immovable or movable property in respect of express trust shall forward Registrar-General for the purpose of subsection 1 all such information relating to trust as may be prescribed, already prescribed that we have seen. Now section 20. This is very interesting section. This is in relation to the investment of trust money. This is in relation to the trust money, not trust property. Right? Section 90 of the Trust Ordinance imposes a duty of the trustees to invest the trust money which is not immediately required for the purpose of the trust. Then there are two pre-requirements set out in that section. First requirement is that the trust property should consist of money. And the second requirement is that such money is not required for immediate use of the trust. Then the trustee must look at the instrument of trust for any directions relating to investment of trust. That's why here when you read this section, where a trust property consists of money and cannot be applied immediately or at an early date for the purposes of trust, then trustee is bound. Then there are preconditions or pre-requirements are there. First part is trust property consists of money, currency. And second thing is not immediately, cannot be applied immediately or at the early date for the purpose of trust. Then only trustee is bound to invest money. That also subject to any direction contained in the deed of trust or instrument of trust. Then first of all, we must see the deed of trust. That's the very important point here. You can't go out of this way. First of all, you must see the deed of trust where there is a clause in relation to the investment of trust money. First of all, there are two conditions, preconditions. After that, if there are money, if there is a trust property consists of money, first place, and second place, the trustee does not use that money immediately for the purpose, then trustee is bound. I would say here, trustee is bound to see any directions contained in the trust deed. That's why here the trustee must look at the instrument of trust for any directions relating to the investment of trust property. In the absence of any direction in the instrument of trust, the trustee must resort to an investment specified in section 20 of the Trust Ordinance. Then there are places where trustee can invest. There are places specified under section 20 where the trustee can invest. The trustee resort to an investment specified in section 20 of the trust ordinance. If the author of the trust gives full discretion to the trustee to invest such money, the trust money, then the trustee must act in terms of section 15 of the trust ordinance. That's what is the section 15? Just now we discussed. That is the reasonable ordinary prudent theory or reasonable man theory. What is that? The trustee is bound to deal with trust property as carefully as a man of ordinary prudence would deal with such property if it were his own property. And that's the duty, that's the standard of care required if there is no directions in relation to the investment of trust fund or trust money in the trust deed. Then what we should do here, if the full discretion, if the author of the trust gives full discretion to the trustee to invest money, the trustee must act in terms of section 15 of the trust ordinance, which requires the trustees to deal with trust property as carefully a man of ordinary prudence. If the trustee determines to invest trust money in any investment specified in section 20 of the trust ordinance, the standard of care stipulated in section 15 of the trust ordinance does not apply, because law requires, therefore, the trustee no need to apply any standard of care, just the trustee can deposit the money whatever specified in section 20. At the meantime, in terms of section 21 of the trust ordinance, you see section 21 of the trust ordinance, a trustee can deposit in a government saving bank or national saving bank. Therefore, a trustee may invest a trust money in any investment specified in section 20 of the trust ordinance or government savings bank or national saving bank if there is no direction in the deed of trust or instrument of trust. Accordingly, I would like to say that a similar section was in the Indian Trusts Act. It was amended in 2016 to deposit the trust money in any of the securities or class of securities expressly authorized by instrument of trust or specified by the central government of India by notification in the Gazette. Because when you see the section 20, it permits to invest the money even in United Kingdom or in the government India or in Pakistan, all these places permitted. For example, if you see the first A, the places given, in promissory notes, debentures, stock and other securities of government of Ceylon or government of Sri Lanka or government of United Kingdom or government of India. When you see the B in bonds, if you invest the money in bonds or debentures or annuities charged by the Parliament of United Kingdom of the revenues of India. Likewise, when you talk about it's a Pakistan matter also here, the stock or debentures of or shares of any railway or any other company in the interest whereon shall have been guaranteed by the governments of India or Pakistan. Because this trust ordinance brought into operation in 1917 when the Sri Lanka was under British rule. Then section 21 amended twice. First amended by Act number 7 of 1968. Then again amended in Act number 30 of 1971. As amended, that the version I put it here, that's the trustees, whatever it is, trustees permitted to invest such money in the government savings bank or national saving banks. Now, in my personal view, it should be amended as soon as possible. Because in my opinion, section 20 of the trust ordinance have become obsolete, and it requires an amendment or substitution to the effect that where a trust property consists of money which is not required for immediate use or immediate use for the purpose of trust shall be invested in any securities, debentures, stock or bonds as may be expressly authorized in the instrument of trust or as may be determined by the Minister of Finance by notification published in the Gazette. In the absence of any clause in the instrument of trust relating to investment of trust money which is not required for immediate use, a trustee who does not invest in securities specified in section 20 of the trust ordinance commits a breach of trust. In the absence of, once again I would like to emphasize this point, in the absence of any clause in the deed of trust relating to the deposit of or relating to the investment of trust money which is not required for immediate use, a trustee who does not invest in securities specified in section 20 of the trust ordinance commits a breach of trust. Trustee will have to make good of interest which such investment would have yielded to the trust fund. That's another additional liability if we fail to do certain things. When the trust money shall be required for the purpose of the trust and the trustee will have to have the trust money available for such purpose, there is no question of investment of trust money in accordance with the provisions of section 20 of the trust ordinance. Once again, when a trust money shall be required for the purpose of trust and the trustee will have to have trust money available for such purpose, then there is no question of investment of trust money in accordance with the provisions of section 20 of the trust ordinance. It shall be the duty of the trustee to restrict himself to the classes of investment which are permitted by the trust deed if the trust deed makes such specific provisions relating to investment and is to avoid such investment not specified which are attended with hazardous. This provision is mandatory unless otherwise directed by the instrument of trust. As the Indian court, Indian High Court held that Section 20 is not controlled by Section 15 because Section 20 requires the trustee to deposit or invest in certain places. Therefore, there is no reasonable prudent man theory at all here. Just the trustee can deposit the money in the places in the places where the Section 20 specify. And the trust money payable to the minor cannot be applied for the trust at early date, as the trustee cannot pay the money until the minor becomes sui juris. In the absence of any clause in the trust deed in relation to the investment, then the trustee shall invest such money in the investment specified in Section 20. If the trustee who fails to adhere to above situation, as I told you earlier, commits a breach of trust. Now we will move to this one. Now the discretion part, that again very important. If full discretion is given to the trustees under deed of trust, the trustee may select or choose the investment as carefully as a man of ordinary prudence would deal with such money if it were his own. However, if the trustee selects an investment specified in Section 20, he is not liable to loss or destruction of such property. That's why in the case specified here, in the Indian case, the Madras High Court held that Section 20 is not controlled by Section 15 of the Trust Ordinance, and the trust monies payable to minor cannot be applied for the trust at early date, as trustee cannot pay the money until minor becomes sui juris. Then we will move to other slide here. This is a very interesting case here. We must see, before we go to that place, we will see the trustee in general have no power to put the trust assets at risks by commencing to carry on a business with the trust fund unless clearly authorized to do so by the deed of trust. Now, if the deed of trust authorizes to conduct or carry on the business, then there is no issue. Trustee, that the duty of standard or the care duty required under Section 15, he must look into that and keep it in his mind, then he can proceed. But if the deed of trust does not authorize anything, then the trustee should not carry on a business with the trust fund. A trust may be created of business or property, including a business, as of other property, and then it will be a question of construction, whether the trustee are empowered to continue to carry on the business indefinitely. Trustee or personal representatives are duty bound to carry on testator's business for the purpose of realization or to sell it as a going concern. It is not open to trustees to borrow on a security of existing trust property in order to acquire additional trust property in the absence of express power to do so. Then what we have seen, what we have studied by this concept, if there is an ongoing business, that is the trust. Trustees is an ongoing business. In that case, trustee must continue to carry on a business until such realization, and we must stop it. You can't carry on the business indefinitely. Trustee cannot do that. Then he must stop it. Or otherwise, that's a second thing. The first place, trustee should not invest the trust fund to carry on a business. That's totally breach of trust. If the trustee is the ongoing business, then they can go, the trustees can carry on a business for the purpose of realization and to sell it as a going concern. And it is not, the trustee should not get any loan or something to proceed or carry on the business at all. That is a breach of trust. Whereas where the trust deed authorizes the trustee to make investment in his discretion, he must be sure about his powers. The courts interprets the investment clauses very strictly. Investment includes application of money in the purchase of some property from which the profit or the interest is expected, and which property is purchased in order to be held for the sake of income which it will yield, where the trustee are given absolute discretion in the matter of investment. They may invest in any investment which they honestly think desirable. The investment in, once again I would like to emphasize this point here, investment includes application of money in the purchase of some property from which profit or interest is expected, and which the property is purchased in order to be held for the sake of the income which it will yield. The trust, where the trustees are given full discretion in the matter of investments, they may invest in any investment they honestly think desirable. This is a case that I mentioned, is an English case that I think I would like to recommend to read this case, but anyway I'll summarize this one here. There was a pension scheme for mine workers which provided for the payment of pensions and lump sums to all industrial employees of National Coal Board on retirement, injury, and on contracting certain diseases, and also for the payment for their widows and children. The funds of the scheme came from contributions of mine workers and by the board. The fund ran into millions. There were 10 trustees, 5 from the union and other 5 appointed by board. Board proposed an investment plan for investment of funds overseas and in energy industries. But the union trustees did not concur in the plan inter alia on the ground that energy industries were in competition with the coal industry. Upholding the investment plan, the court held that in the case of a power of investment, the power must be exercised so as to yield the best return for the beneficiaries, judged in relation to the risks of the investments in question and the prospects of yield of income and capital appreciation. Both have to be considered in judging the return from investment. In considering what investment to make, trustee must put on one side their own personal interests and views. Trustee must strongly hold social and political views. They may firmly oppose to any investment in South Africa or any other country, or they may object any form of investment in companies concerned with alcohol, tobacco, ornaments, or many other things. In the conduct of their own affairs, of course, they are free to abstain from making any such investment. But here, under a trust, if the investment of this type would be more beneficial to the beneficiaries than other investments, the trustee must not refrain from making the investments by reason of views that they hold. Very clearly, the court said that always the trustees must see the benefit of the beneficial interest to the beneficiaries. It is open to the settlor or testator to give directions as regard to the investment of trust fund, and when the direction has been given, they have to be adhered to by trustee. It is useful to cover wide power of investment on trustees to enable the trustees to choose the most suitable mode of investment. The investment clause in the deed of trust receives a strict construction, and so any direction in that behalf must be expressed in clear terms. Then we will see section 20, paragraph F. Again, that's very important section. Before we go into that one, we will see the trust property consists of shares. Now, sometimes the trust property may be the shares of the company. When the trust property consists of the shares of a company, the trust deed authorized the trustees to retain the shares in such company. Such direction does not hold good when there has been reconstruction of company, and the trustees are not obliged to take the shares of the reconstituted company. If they use the discretion honestly, they would not be liable. If the trustees use the discretion honestly, they would not be liable in the event of depreciation or loss of property, trust money. Then we will see section 20F. 20F on a first mortgage of immovable property situated in Sri Lanka or United Kingdom. There is a proviso to that paragraph. The property is not a leasehold for the term of years, and that the value of the property exceeds 1/3, or if consisting wholly or mainly of buildings exceeds 1/2 of the mortgage monies. Then when you see this one, the paragraph F of section 20 enables the trustees to invest the money on the first mortgage on immovable property. This is, however, subject to the proviso that the property is not a leasehold for the term of years and the value of the property exceeds by 1/3, or if consisting of building exceeds by half the mortgage money. Therefore, the trust ordinance empowers the trustees to invest, but only on the first mortgage, provided the property is not leasehold property for the term of years, and the value of the property exceeds 1/3 and the if consisting of building exceeds half of the mortgage money. In England also, investment of mortgage has not been permitted unless investment on real securities is expressly authorized by deed of trust or instrument of trust. And even if so authorized, it can be on a first mortgage or first charge by way of legal mortgage. Even in England, the leasehold for, however, longer term could not form to be subject of investment of trust fund. Section 5 of the English Trustees Act of 1925 has authorized investment of trust fund on long leases at normal rents if they do not contain a power of redemptions. There is a present legal position in respect of mortgage of leasehold interest in England. In England, it is not open to the trustees to lend on contributory mortgage, reasons being that they put themselves out of the powers for recalling the investment of taking action in respect thereof. Provisos to Clause F clearly provides that for investing in first mortgage of immovable property applies the value of the property exceeds 1/3 or if consisting of building exceeds half of the mortgage money. So the first investment of for investment of such first mortgage, the trustee must take care to ascertain the fair value of the property and advance only such amount as would leave a fair margin. It is the value of the property of security of which the property fund is lent by way of mortgage is uninfluenced by solvency of borrower, which is important. In England also, the advance should not be more than 2/3 of the value of the value of the property to be mortgaged, or if it is a house property, amount advance should not exceed half of the value. In these cases, the best idea to value the property for the safe side. That's why the fair value must be identified. Then only we can say there's a safe side to the trustee. Then we will move to section 22, where the trustee directed to, this is trust for selling or sale of property. Where the trustee directed to sell within a specified time, extend such time, the burden of proving as between himself and beneficiary that the latter is not prejudiced by the extension lies upon the trustees, unless extension has been authorized by court. There may be a trust for sale within absolute direction to sell immediately or within a specified time, or the time of sale may be left with the discretion of the trustee. And there are three matters: the trust for sale, absolute discretion to sell immediately. The second choice, sell within the reasonable time. Third thing is, the time of sale may be left with the discretion of the trustees. Section 22 contemplates that it is a trust for sale when the trustee has no discretion, but he has to sell the trust property within a specified time. In such a case, if the trustee extends such time, then problem. Then the beneficiary acquires a right to complain that by such action he has been prejudiced. In such a case, as illustration to section, just to see the illustration here down of section 22, indicates that beneficiary has the right to sue the trustees for compensation, and in such a suit, if the trustee extends to defend such extension by taking the plea that extension has not prejudiced the beneficiary, the burden to prove that defense is upon the trustees. However, trustee shall not be liable for damages to the trustee if the trustee approaches the concerned civil court, that's a district court, to authorize him to extend the time fixed by said law for such sale. It is held in the case that I have mentioned in the open presentation. It is held by the Calcutta Court, High Court, that section 22 appears to be absolute. Section 22 appears to be absolute. For illustration, make it clear that even if the discretion is exercised reasonably, suit may be lie. And in such a suit, the trustee has to establish that by such extension, beneficiary has not been prejudiced. Further, we can see that when the trustee refused, now say you have to sell it, the trustee must sell it within the reasonable time. That's true. If the trustee refused two good offers and after 5 years' time sold such property for half amount offered previously, trustee were liable to make good the differences. However, section 20, then when you see the power of sale discretionary, however, section 20 does not take note of such cases when the trustee has been given discretion relating to a sale of trust property. In such case, the trustee will not liable if for exercise or non-exercise of power as long as they have acted bona fide and honestly. In such cases, the court will not interfere with the exercise of wide discretion which has been given by settlor to the trustee as to when he would be entitled to sell the trust property. However, that does not mean that the trustee would not exercise such discretion reasonably and would postpone the sale indefinitely. Once again, that does not mean the trustee would not exercise such discretion reasonably and would postpone the sale indefinitely. A discretion to the trustee to sell at such time and such manner as the trustee shall think fit does not mean that trustee have authority to adjourn the sale indefinitely. But we have seen here that should be done. If there's a trust for sale, if the time frame is given there, that should be done within the time frame. If the discretion given, it doesn't mean that trustee can delay indefinitely. That should be done. The property should be sold within the reasonable time. Otherwise, the trustee liable to the breach of trust. Therefore, discretion is given, but the discretion given in the sense you can't abuse such discretion. The trustee should not abuse such discretion. He must act honestly and bona fide. Then we will see other matters relating to liability for the breach of trust in another lecture. Thank you very much.